Federal judge blocks IRS, DHS immigration data sharing program. A federal judge has just blocked the IRS from sharing taxpayer information with the Department of Homeland Security for immigration enforcement. This is a big decision, and I'm going to break down exactly what happened and why it matters and how it could impact you or actually your family members or your loved ones. It's on November 21st, a federal district court issued a preliminary injunction stopping the Internal Revenue Service, the IRS, from sharing taxpayer data with the Homeland Security and ICE. This data included names, addresses, and tax-related identifying information. Earlier this year, in April, the Treasury Department and DHS created a system where ICE could submit lists of people suspected of being in the U.S. without lawful status. The IRS would then check those names against its tax database and send back matches. According to reports, there were about 1.2 million records submitted, and the IRS sent back around 47,000 matches. It's important to know why the judge blocked this. This is where the ruling gets really important. The judge found that the data sharing program likely violated federal tax confidentiality laws, specifically 26 U.S.C. Section 6103, which says taxpayer information is supposed to remain private unless very specific exceptions apply. The court also said that the IRS failed to provide a legal justification for giving immigration agents access to confidential taxpayer records. The program created a chilling effect, meaning immigrants were avoiding filing taxes out of fear their information would be used for deportation. That chilling effect was already causing harm to both taxpayers and the government because fewer people were filing returns. And because this harm was urgent and ongoing, the judge blocked the program immediately. So what does this injunction do now, right? The injunction means the IRS cannot share taxpayer data with the DHS for deportations or immigration enforcement. ICE cannot use previously shared IRS data to conduct removals unless they can show a lawful basis. IRS data can still be used for legitimate criminal investigations, but not for mass immigration sweeps. This is not a final ruling, it's a preliminary injunction, but courts only issue injunctions when the plaintiffs are likely to win the case and there's a risk of serious harm. So this ruling is actually especially important for asylum seekers, people using ITINs to pay taxes, mixed status families, undocumented workers filing income taxes. For years, the government encouraged undocumented immigrants to file taxes, often with an individual taxpayer identification number, which is called ITIN, without fear that their information would be used to deport them. This new data sharing program threatened that trust. If immigrants fear that paying taxes exposes them to deportation, fewer people will file returns and the entire tax system suffers. The judge recognized this and pointed to real evidence that immigrants were already avoiding filing taxes because of this program. This case, of course, we're going to see how it's going to turn out, but we can see that there's increased attempts use non-immigrant agencies like IRS, Medicaid offices, and state databases to support immigration enforcement. Even though judge stopped this program, similar efforts may continue. And so here's what you should keep in mind. Your tax information is still protected by law. The IRS cannot legally hand over your personal data for deportation purposes. If you pay taxes with your ITIN number, this ruling strengthens your privacy rights. This is a reminder of stay informed, stay compliant, and stay protected. I hope today's video is helpful for all followers. And if it is, please make sure to like, subscribe, and hit the notification bell so that you don't miss the future updates on immigration law and policies. And have a great day. This is Attorney Ayhan Ogmen.